remember, Palestine is a party to the International Criminal Court, and the court has jurisdiction over anything that occurs on Palestinian territory, so that the actions which take place in Gaza itself, even though Israel is not a party to the International Criminal Court, nevertheless, in its operations on Palestinian territory, the court would have jurisdiction over those. The difficulty, of course, would be apprehending the people and arresting them, or and sending them onwards. But as we've said, and you've just pointed out, the International Criminal Court isn't the only possibility. There's also the possibility of just trial within Arab countries themselves under national laws.
Hello, everybody. I'm still here talking to Professor Steve Neff of Edinburgh University, the world's leading expert on the law of neutrality. And in this second segment, we actually want to talk about current affairs. So the law of neutrality and the role of neutral states is always it's always disputed, right? As you said in the first segment, it's like, can this egoistic approach at international relations of not throwing yourself into the, on the good side of history, right? Whichever side that is, both sides always claim that they're on the right side of history, right? But throwing yourself not in there, can this approach actually have a positive effect on the international arena? Now, looking at the Ukraine war and also looking at the current very horrible war in Gaza, in Israel, how do you judge how neutrality at the moment is unfolding or not unfolding?
Well, let me talk about the Russia-Ukraine conflict. That's the clearer example, since it is between two sovereign states, so that it is a war of the traditional kind that lawyers have dealt with. One of the striking things is how the little role the law of neutrality has played so far in the conflict, because there have been egregious departures from the law of neutrality on the part of the NATO states and Western states in general. There have been significant long-term supplies of armaments to one side, with a view to their being used against the other side. The traditional law of neutrality was somewhat lenient in cases in which there were pre-existing arrangements, say to supply arms. For example, if two countries had a long-term arrangement where one would continuously supply the other with arms to bolster its armed forces. And the question is, what happens when the recipient of that then enters into an armed conflict? Does the supply of arms have to stop? And the general view that was taken was that no, it didn't. So long as the original arrangement wasn't directed against a particular state, it could continue along the lines as before. There couldn't be an upsurge in the quantity of weaponry delivered, but just carrying on with the pre-existing arrangement was permissible. But in the case of Ukraine, there were not pre-existing arrangements. The arms supplies began precisely because of the invasion, with a view to the weapons being used against the Russian forces, so that there has been flagrant and egregious non-neutral conduct on the part of the NATO states. Now, some would say, of course, that's a good thing, because it's helping out the victim against the aggressor, but this is a resort to the collective security mentality. Of course, and we're seeing something like the collective security outlook in concrete force and effect in Ukraine. The idea being that large numbers of states will rush in and help a victim against an aggressor. And but if you look at it from the standpoint of the law of neutrality and the traditional law, you would say that this is flagrant lawbreaking going on the part of the NATO states. Now, Russia hasn't seemingly made any great point about that. They haven't made any attempt as yet to attack the NATO states and try to cut off the arms flow at the source, as it were. And everybody is afraid that that might change at some point, because they're under the traditional law of neutrality. It is based on the principle of military necessity, and that if unneutral behavior is going on, then the belligerent that is prejudiced by it can take action against the non-neutral states, that is effectively by way of reprisal for law breaking. So there are constant worries that the war might expand on that basis. Russia has so far held back from that, but we don't know if that is really going to last. And perhaps more interestingly, and I think more immediately, will be the war at sea, about which strangely little information goes out to the general world on that. It is sometimes said or spoken as if there were an actual blockade by Russia of the Ukraine coast, but I don't think that seems to be the case at the moment. The problem was the danger of ships going through and trading. Insurance rates were so high that it made much of trade unfeasible. But what has happened now that the grain export agreement has been discontinued is that Ukraine is moving its ships hugging the coastline of the Black Sea until the ships can get into Romanian and Bulgarian waters. They are NATO states, in the confidence that Russia won't attack them when they're in those territorial waters. That being a traditional principle of the law of neutrality, that belligerents cannot engage in belligerent operations on neutral territory or in neutral waters. But there is the problem that along the coast of Ukraine itself, the ships will be subject to attack. Now, I think that there have not as yet been attacks as yet, but that again, that may change at some point. And we saw in the Iran-Iraq war that the tanker war was instituted, in which Iran and Iraq began. Iraq particularly was targeting ships exporting oil. They were targeting exports from Iran rather than imports to it, which is what one more intuitively thinks of the law of neutrality as being concerned with. That is, blockades keep people from going into the enemy state, and capture of contraband prevents weaponry being shipped, again, into the enemy state. But nowadays, where economic relations are so important, there can be targeting of exports from the enemy states as a way of crippling the enemy economically. And there is an area in which there is much yet to be settled or determined about neutrality law even now. Clear rules did not emerge from the Iran-Iraq war on that, and we may at some point be seeing something like that happening in the Ukraine conflict as well, although as yet things have been eerily calm.
Yeah, but and it's, to me, the opposite is actually going on at the moment. If you look at the approach that especially NATO member states and the Western countries, including Japan and Korea and so on, took, it was basically to declare a blockade on Russia, right? Especially when it comes to Russian oil. The idea that Russia itself is now shouldn't be traded with anymore, and going so far as to do this infamous secondary sanctions. The United States has been using secondary sanctions on non-complying states for a long time, but now the European Union too has been moving to sanctioning not only Russia, but also states that did not comply with its, that would help Russia to circumvent these sanctions. And this, to me, is a very similar concept to the concept of blockade. I know it's not the same, and under international law, I think I actually want to ask you, on international law, how are these sanction systems regarded? Are they legal? Are they lawful? And what about the secondary sanctions? Do you think that this development might have an impact on the development of neutrality law in the 21st century?
That is entirely possible. And use of secondary sanctioning has been a very controversial issue. And as a matter of fact, strangely enough, as you mentioned this, that was how I first came to have an interest in the law of neutrality. My original interest was in law relating to economic sanctions. And in the course of research from that, I came across readings about activity like that, about stopping trade during warfare, that is by capturing contraband and blockades, and I became very interested in that, and so neutrality became my primary interest. But it's very much the same kind of thing as secondary sanctioning. And a classic example is the law of blockade itself, in which you keep the entire world from trading with the blockaded area, and everybody is kept out. So that's secondary sanctioning of the most stark and clear character. And for a long time, secondary sanctioning was controversial. The Arab states engaged in it in the Israeli, the anti-Israel boycotting, and the United States elsewhere. And the United States wasn't very successful at it because there was so much resistance from the world. But there has never been a clear legal position that has emerged as to the lawfulness or otherwise of secondary sanctioning. And the argument about secondary sanctioning is essentially, as you point out, that of neutrality. You are inflicting penalties on people who are exercising their rights. The other states have a perfectly good legal right to trade with both countries in warfare or unfriendly countries in time of peace. And so secondary sanctioning is a direct analogy with the law of neutrality and the infringement of the right of neutrals to exercise their ordinary freedom of trade. And now there has never been court cases or tribunals that have accepted that argument that secondary sanctioning is actually illegal, but there has been much pushing back against it. And one of the striking things about the Ukraine conflict is that it demonstrates that when the countries are standing together, in other words, when it isn't just the United States imposing secondary sanctions, but it's when all of the NATO countries and even beyond NATO get together, is how powerful and effective that can be when they really do hang together. And it's been one of the great surprises of the Ukraine conflict, that as to just how much of a sense of solidarity the NATO and Western states have shown. Whether that will continue, of course, remains to be seen, and there are signs of cracking very audibly, right, as we speak. So we don't know how far that will go. But so long as the NATO states and others are actually on board and all applying the same sanctions, then they can be very effective, even if they don't engage in secondary sanctioning against other states such as India and China and such. And my impression is that they have largely been holding off of secondary sanctions and relying on their own collective economic might. But you maybe have more information on that than I do. But so far things have been quiet on the secondary sanctioning front, but that is subject to change.
I think Ursula von der Leyen, a couple of days ago, she announced the 12th or 13th sanction package, and she said that in that package, like, more secondary sanctions are going to be taken. It's going to be more it's going to be more strict on third states that would help circumvent the sanctions. So we might see a change there, but that's very, very recent, only a couple of days ago. The issue, though, that we see is also that I am not that sure of how effective those sanctions are, because on the one hand, Russia's economy has been growing the whole year. The German economy is stagnant, and other NATO state economies are actually even shrinking. So there will be a question of the effectiveness of it, but also that it created basically 2/3 of the world that said that they want to continue trading with Russia normally, and there must be now a tension between this. Or there is a tension between the global South countries and their rights of continuing normal trade with all belligerents. So I would expect that this should have some repercussions. But maybe let me also ask now about what's the case for neutrals under international law when it comes to the most egregious war crimes like ethnic cleansing and genocide? Because as we see right now, what's happening in Gaza, my question really is, what can neutral states do? What should neutral states do, or those that are not directly involved in the conflict, when we see that, you know, ethnic cleansing might actually happen or might be occurring right now?
Yes, that's a good question. And so far, and in general, international criminal law just goes on a completely separate track from the law of armed conflict or law of neutrality. And I think that we don't have really concrete law on this, but I think there's no doubt that neutrality does not prevent action against individuals who have been involved in war crimes. In other words, arresting, say, a war crimes suspect or somebody who is thought to be involved in crimes against humanity or war crimes, if they go into the territory of a neutral state, I think there can be no legal objection to their being arrested in that state and prosecuted in that state itself under universal jurisdiction principles or under the law of the Geneva Conventions. The Geneva Conventions set out a series of what are called grave breaches of the conventions, and every country that's party to them, which is every country in the world virtually, is obligated to take steps against the persons when they are in the territory. So I think if a neutral state finds somebody who's been involved in or is suspected of being involved in international crimes, that they are perfectly entitled and indeed under the Geneva Conventions actually obligated to take legal action against them, because these are legal actions against individuals in their own right and not against states as such. So I think the law of neutrality does not to any extent stand in the way of enforcement of international criminal laws.
We have seen this case of Vladimir Putin and the ICC. The ICC, the Rome Statute that now has indicted Vladimir Putin and one more government official, and that had some real repercussions in the sense that Vladimir Putin did not travel to South Africa, for instance, which is a signatory to the Rome Statute. But what you're saying is that under the Geneva Convention, each signatory to the convention could itself actually start war crime or human rights violations trials at home, and in that way kind of threaten individuals who commit these crimes. Is that correct? Would that be a way to go about it?
Yes, that is correct. Though bearing in mind that the Geneva Conventions cover only war crimes, and the list of grave breaches, as they are called, and those are set out in the Rome Statute as well and repeated there. But the Geneva Conventions do not cover genocide or crimes against humanity. Now, many states have legislation on those things, particularly crimes against humanity, allowing them to take legal action to prosecute people in the home states, even if the acts took place in a different country, even if the victims were foreigners, that none of that matters. It's called universal jurisdiction in legal circles, and that action can be taken. There was and there is law on this. There was a prosecution, notably in Germany, for some years ago, of a person for genocide and emerging out of the Bosnian War, I think for involvement in the 𝗓𝗡𝗂𝗧'𝗦 massacres. And the person was found in Germany, so the German authorities arrested him, prosecuted, and convicted him. He then took the case to the European Court of Human Rights, saying that Germany can't do this because the actions took place in a foreign country and Germans were not involved as victims and such. But the European Court of Human Rights said that no, this is permissible, that universal jurisdiction is allowed against international crimes such as genocide or crimes against humanity. And so their states have the option of taking action. And in the case of war crimes under the Geneva Conventions, it's actually an obligation to act. But for genocide and crimes against humanity, it is an option rather than an obligation. But countries are allowed to do that, and one does see examples of that on a modest scale occurring.
But that means it would be a possibility actually that Arab states, but also other states that currently are already signaling very strongly that they condemn the wholesale bombing of Gaza and the killings of 10,000 civilians, that they could actually start using their own legal systems of going against individual Israeli politicians that they suspect of being the perpetrators of war crimes, and thereby put even legal pressure under their systems on these individuals.
Yes, that's correct. And many prominent Israeli politicians and politicians elsewhere, like Mr. Putin, are careful about the countries they travel to. And I think leading American politicians, such as former President Bush and people in his administration, I think take care not to go to foreign countries unless they are very sure that there won't be action taken against them on these universal grounds. And it's worth bearing in mind, too, that remember, Palestine is a party to the International Criminal Court, and the court has jurisdiction over anything that occurs on Palestinian territory, so that the actions which take place in Gaza itself, even though Israel is not a party to the International Criminal Court, nevertheless, in its operations on Palestinian territory, the court would have jurisdiction over those. The difficulty, of course, would be apprehending the people and arresting them or and sending them onwards. But as we've said, and you've just pointed out, the International Criminal Court isn't the only possibility. There's also the possibility of just trial within Arab countries themselves under national laws.
That is very interesting. And I hope a way that might be a legal way of putting pressure. But let me ask you a last question. And this is more, again, back to the law of neutrality, which we have said has been kind of frozen in place for the last 100 years and not developed very much. Now, on the other hand, we do see that the post-Cold War era, like the post-Cold War that lasted basically 30 years, and I think that one is now fading or is over, and we're entering a new period, and a lot of international relations scholars describe this now as a new multipolarity. And I do think that there's a strong argument to make that under this new multipolarity, the forces should be such that would allow neutrality law rather to start developing again, because there would be an interest of states. And we see that already, especially in Southeast Asia, that certain countries are more interested again in talking about neutrality, and also sea lanes, neutral sea lanes, which is kind of back to the origins, right? Neutrality is actually a maritime concept originally, not one on land. If when in ASEAN, the ASEAN itself still has the concept of the zone of peace, freedom, and neutrality. and also of being a nuclear weapon-free zones. And if any of these countries actually asked you as an expert, Dr. Neff, looking at how this adversarial relationship between China and the United States is going on, and how they are trying to control also sea lanes of communications, which infringes upon the non-involved states' trading possibilities, what would your recommendation be, what they can do in order to start developing new concepts of securing neutral trading routes and trading possibilities with not only with the belligerents, but with the other neutrals or non-involved states as well?
And, well, this would come to be particularly serious if there were actually a shooting war to be breaking out. If, for example, there is an invasion of Taiwan by China, for example, which might very well involve the United States, and then there would be serious questions here. But I would suggest that they look into the possibility of bringing some kind of action in the World Court, if that is possible. The United States is not a party to the compulsory jurisdiction element of the World Court, so it would be difficult to bring a case against them, but not impossible, because the United States may be parties to treaties on particular subjects that could be brought in. Another possibility, though, would be an advisory opinion from the World Court, which could be pushed through by a 2/3 vote of the UN General Assembly. And it may well be that non-aligned countries, to use just a convenient term, that non-aligned countries might have the political strength in the UN General Assembly to push that through, as there are two requests at the moment for advisory opinions from the World Court. So that's a mechanism which has been used on several occasions, and so those would be possibilities as well. But I think one would have to look at the particular situation to see what might be feasible in a particular setting. For example, what kind of trade precisely might the United States or China be interfering with, and how serious is that, and what are the possibilities of economic measures in response to that as countermeasures, because general international law allows countermeasures. We used to call them reprisals, but they're now called countermeasures to be taken in cases of illegality as a self-help measure. So one would have to look at the particular context and what was happening to see what would be legally feasible at the moment. But there are a variety of legal mechanisms in place which could, in principle, be used.
And when it comes to like making treaties with these states, we've had for a long time this tendency towards making like global schemes of trade, the World Trade Organization, of course, being the biggest one of those, but they are now dysfunctional because they're being kept in disarray also by like not appointing judges to the arbitration to the appeals court. The other system that we used to have, especially in the 19th century, is of course one that developed together with neutrality, which is arbitration. And would you recommend states, lateral states, especially in Southeast Asia, to put more emphasis or to put more effort into adding arbitration clauses into their trading agreements, especially with larger parties, or not? Because I feel that arbitration might be an alternative system for dispute settlements in a more multipolar world.
Yes, that would be a very sensible thing to do. I don't know how commonly it's done now, but for ordinary friendship treaties or friendship and friendship, commerce, and navigation treaties, they're sometimes called, it's not uncommon for there to be a provision in there for settlement by the World Court. For example, that's how the United States and Iran have been litigating various issues over the years. There was a friendship treaty from the 1950s which remained in effect and that provided for world court jurisdiction. So that's what has enabled that to happen. So it would be perfectly possible and feasible and a good idea to include arbitration clauses. And there's a body called the Permanent Court of Arbitration, which exists. It's a somewhat misleading name.
In The Hague.
In The Hague, yes. And it's a somewhat misleading name, but it's a mechanism for the formation of arbitral panels. And they have many cases on at the moment, both interstate cases and investment disputes between private companies and states. So the Permanent Court of Arbitration is active, and there is a substantial mechanism there. And it would be a good idea for trade agreements and economic agreements and such to make explicit provision for that.
So overall, you're rather hopeful for the future of international law to keep providing a framework for the civic engagement, even with between states that are in conflict.
Yes, cautiously optimistic. International law is, I suppose, it's a subject for optimists. I don't know if you were not of a generally optimistic turn of mind, you would find things too depressing. So we are sort of professional idealists, and in my line of work in international law. But there are countless challenges, but some glimmers of hope. Yes.
I'm glad that we can finish on glimmers of hope. Steve Neff, thank you very much.